Well, good morning, good day, good afternoon, good evening to everyone that's joining us today. I'm here in Newport, Rhode Island. We're finally getting a little bit of warm weather, but not too much. But thank you all for joining us, and thanks to all our panelists that are going to be speaking today on maritime security issues concerning small island states. We have three speakers today. Unfortunately, one of them is unable to join us in person, so we'll be seeing a tape presentation. But our first speaker will be Cleo Pascal. She's an associate fellow with the Royal Institute of International Affairs in London, also known as the Chatham House, as well as a non-resident senior fellow for the Indo-Pacific and the Foundation for Defense of Democracy in Washington, D.C. Our second speaker, which will be taped, is Lieutenant Commander Dominique Bourdillard, who is a French naval officer and is the chief of the Sea Law Enforcement Office in French Pacific Command in French Polynesia. And then we'll wrap it up with Professor Masahiro Kurosaki, who is an associate professor of international law and the director of the study of law, security, and military operations at the National Defense Academy of Japan. So, Cleo, I'll turn it over to you as our first speaker.
Thank you very much, Professor Pedrosa. It's a great pleasure to be with you, and thanks to JIA and the U.S. Navy War College, the World Maritime Institute, the Nippon Foundation, Sasakawa Peace Foundation for holding this very important event, very timely given all the activity going on in the region. I do have a PowerPoint presentation, so fingers crossed as I see if I can make my screen share. And let's see, there we go. How's that look?
Good, we can see it.
Good, great. So I'll be talking about islands in the context of not just their own maritime security, but regional maritime security, and specifically in the regions of the island chain defense concept. And I'll be looking at from the point of view of how geopolitical, geoeconomic, and geophysical change. Geophysical can include climate change, but also other things that affect the physical environment could be creating new situations that aren't necessarily covered in ways that we would like by existing treaties or legal structures, and where we could have a problem. Now, we know this very well. This is going to be covered elsewhere in the conference, and we've known this for years. Issues around, for example, island building. We know geopolitics, we know geoeconomics. This is sort of what the geophysical change can bring to the fore in terms of creating instability. This is Fiery Cross Reef before and after. The location where I'm going to be focusing on is mostly the second island chain. Now, we know that the first island chain, second island chain have been core to the strategic construct of understanding the region for a very, very long time, before World War II, in fact. And we know that it's central to the way that China has been looking at the region as well. So this is from the PLA Navy Headquarters 2012 publication, where you can see there the lines, the first island chain and the second island chain lines often change depending on who's drawing the lines. This is the Chinese version. And the issue, of course, is you can see it either as China trying to be constrained or China needing to break out. And when you overlay a map of the island chains over the Silk Roads, you can see that getting through the island chains, even just for the stated economic purposes, becomes extremely important. For defensive purposes, of course, even more. So the two red lines here are this map's definition of the island chains, and the kind of green and yellow lines are Silk Roads. These are countries that, to some degree or another, have signed onto the Belt and Road. The Belt and Road, of course, presented as economic, but potentially strategic as well. So these little islands, these small island states, are becoming increasingly highlighted, both in terms of expansion and in terms of constraint. So the question is, how, given the current legal framework, and I know my co-panelist will be talking much more about the UN Convention on the Law of the Sea, which will be very helpful, how does Beijing view the existing legal framework, and will it be helpful for creating rules that we can all follow? So we put together, Chatham House, we spent 2 years doing a study, it came out in March, on perceptions of strategic shifts in the Indo-Pacific from the point of view of 7 countries, the UK, the US, France, India, Tonga, because we wanted to understand what was going on in the islands a little bit more, Japan, and China. And as part of the study, we had a standardized survey, which all of the participants in the various countries responded to. The participants were members of the strategic and policy communities in those countries. Of course, it's always complicated getting information out of China. The person who did the survey in China is a Chinese colleague who did it through mostly one-on-one interviews. One of the questions that we asked was, did you think that the UN Convention on the Law of the Sea would still have legitimacy in 2024? 2024 was the timeline. Of the Chinese respondents, all Chinese scholars interviewed said the UN Convention on the Law of the Sea no longer reflects the reality of the current international regime. Some of the scholars who had a strong military background believed that UNCLOS would no longer be valid by 2024, and the foreign policy experts thought that it could perhaps just have a moderation to make it more fit for purpose. Both schools of thought concurred that it was China's intention to be more proactive in establishing itself as a maritime powerhouse that can shift the region's balance of power. We additionally asked, did they think that there was a likelihood of kinetic conflict by 2024? And in the case of China, all of the respondents said yes. The variation had to do with the scale of the conflict, whether it would be a lot of small conflicts or whether it would be escalate to something kind of major. These responses, the viability of UNCLOS and kinetic conflict by 2024, were outliers for the most part. With the other 6 countries, there was very little questioning of the legitimacy of UNCLOS. And in terms of kinetic conflict, there were mixed results. So we know that Beijing is not pleased, as is demonstrated in this survey, but also in many other pieces of research, with the current construct. So how are they going about trying to achieve what their goals are in terms of shifting the balance of power? If you look at the island states, it tends to be pretty consistent. So these are the first 2 geos, the geopolitical and the geoeconomic components of it. The engagement with the small island states tends to be pretty consistent. This is a framing that was put together by Colonel Grant Newsham, retired U.S. Marine, who's currently based quite a lot of the time out of Japan, where it shifts from goodwill to support to dependency through a range of methods. So they've appointed Guangdong, for example, as a dedicated outreach point for the small island states. Instead of dealing with Beijing, a lot of the research institutes and economic outreach goes to Guangdong. Chinese representatives learn the local languages. When they're based in the country, there's money for pet projects, there's construction of infrastructure, there's a focus on engagement in the small island states with immigration, customs, security, public enterprise, and education. A lot of those have to do with bypassing strict, how can I put it, investigations into what's going across the borders for those countries. So it can be quite a serious maritime security issue. There is an increasing amount of transporter crime that is affiliated with China through this. Obviously, the loans, there's a push to get countries to lower restrictions for Chinese nationals, visa restrictions. The casinos, where they accept the casinos, the Chinese casinos are also a big hub for money laundering. A lot of high-level visits back and forth. It's very easy for people from the region, from Oceania region, to visit China. Much more difficult, for example, for them to get visas to Australia or New Zealand. Scholarships, there's medical support, Chinese workers rotating through the region. And again, with them comes a lot, in some cases, comes into transnational crime. So what we seem to see is that the initial engagement is presented as commercial, but it has a strategic core to it And welded into that is some criminality and corruption that can definitely affect maritime security. It's this kind of braided approach. And basically, it's very competent statecraft combined with a lack of coherence on the part of Western partners and others to offer a viable alternative. And so the borders get weakened. And we're going to take a quick look at a specific case study, which is in the news quite regularly now, which is the Republic of Kiribati. On this map, just to give an idea of the strategic balance of power, everything that is deep red belongs to the United States as part of the US. Everything that's pink is Japan. Turquoise is France. You can guess the rest. The Kiribati is in 3 sections. So the Kiribati is outlined in kind of dashed red lines. It covers a very strategic zone in the middle of the Pacific, and it's next to several US critical locations. Kiribati has gone back and forth between recognition of Taiwan and China. So in 2003, it had recognized China. It was recognizing China. China set up a monitoring station. Kiribati de-recognized China, recognized Taiwan, closed down the station. That's how it stood until 2019, when it flipped back to China, along with the Solomon Islands, in part as a result of that very successful kind of goodwill to support to dependency structure for specific elements within the political groupings. There was a big offer of infrastructure, and that was extremely appealing to the small island states. And part of that infrastructure brings in our third geo, which is geophysical change. And it looks like there may have been discussions around China moving its magic island-making ships, the ones that built the islands in the South China Sea, some of them, those dredgers, into the region to help reinforce some of those islands in the region that have been affected by climate change. We know that this offer was made to Tuvalu. Tuvalu recognizes Taiwan and rejected the offer. But in the case of Kiribati, it may not be rejecting the offer. And to look very specifically at what that kind of strategic engagement might mean, there's an even more pertinent example which has just come up, which is that China has said that it's exploring feasibility of upgrading an old US World War II airstrip on Canton Island, which is in Kiribati. This is such a new situation that we're in the process of digging out old treaties to see whether anything can be done about it. And the relevant treaty in this case would be the Treaty of Tarawa, which essentially says that when Canton was handed back to the independent Republic of Kiribati, that the US could build a facility there if it wanted, in discussion with the government of Kiribati. And they shouldn't, in any case, Kiribati shouldn't allow any third party to set up anything military without the agreement of the government of the United States. I've asked State Department for clarification on this, and I'm waiting back to see whether this is still in force and what that might mean. These islands seem remote, but they are highly strategic. So if you take a look at, for example, this is from Commander Salamander's website. It's a very useful map. If you take a look at the direct route between San Diego and Australia, it goes in a kind of straight line. So you think Canton might be in the middle of nowhere, but actually it's about 28 miles off that line in the middle of a place which could use resupply. It's also extremely useful for monitoring. Would be helpful for a country that has potentially strategic malign intent in the region. And to remember, in conjunction with all of this, is that the way that China's military capacity is developing, the dual use component is becoming embedded and much more difficult to identify. So, for example, recently there's a news report about China building long-range cruise missiles launched from ship containers. So shipping through the region becomes complex from a strategic perspective if you can't even identify at all where the missiles might come from. Now, what are Western allies doing to handle this situation? This is a larger map of the region. It is politically, if not ethnically, the ethnic division doesn't really make sense, but politically, the region has been divided into these three sectors: Polynesia, Melanesia, and Micronesia. Recently, to give an idea of how poorly the region has been handled by allies, the Pacific Island Forum, which had a membership of the 16 Pacific Island countries plus Australia and New Zealand, fractured, this was in February, with 5 of the 18 members, all of the Micronesian states, which include the 3 US freely associated states, announced that they would be pulling out of the Pacific Island Forum because they didn't feel like they were represented in the grouping, and they had made a stand over the leadership of the Pacific Island Forum. There was a vote for the Secretary General, and they felt that it had been, and they were correct, that it had been a very long time since anybody from Micronesia had headed the forum, and that there had been a gentleman's agreement that it would be more or less rotated. Their time was due. They put forward a candidate, very qualified candidate. The vote did not go their way. It went in favor of somebody from the Cook Islands. And the vote was very close. There was a 1 vote difference. 2 countries that voted against them were Australia and New Zealand. And so the perception is that Australia and New Zealand created a situation where the Micronesian countries said they were going to leave. Once the vote happened, they left. And so either from the Canberra and Wellington side, either that was a failure of intelligence, they didn't understand that the 5 Micronesian states would really leave, or else it was a desired outcome and that the fragmentation was fine with them. And this is a developing situation. The strategic analysis is still ongoing, but there is a question about whether New Zealand in particular wants to create kind of more of a Polynesian zone where it plays a bigger role, and that plays into the Five Eyes agreements. So quite recently, New Zealand said it was uncomfortable with the way that Five Eyes was taking more of a political stance, open stance on some issues. And there's been a lot of questioning about the role of New Zealand going forward, and especially in the context of China, how firm an ally it is, which of course opens questions about a reassessment about strategic realignment in the region, and potentially maybe, the undervaluing of Japan as a partner in the region, and especially in the Pacific Islands. Japan has a very large presence in the Pacific Islands and has been very helpful in terms of development and infrastructure projects, very low key, but very effective. So at the same time that we have a China that is disregarding seemingly inconvenient pieces of legislation and treaties, we have an alliance network that is being reassessed, and new members coming into the region. We've got the France issue, we have the UK reopening diplomatic posts, the integrated review was released recently in the UK, which announced an Indo-Pacific tilt. We have more defense procurement. So there's a lot of moving, and the US is coming back in a way that we haven't really seen before. And we can see that very clearly in the shift with what happened in Palau just in the past 2 or 3 years. So Palau is a US freely associated state. It has a compact of free association with the US. It recognizes Taiwan. China ramped up tourism to Palau, and then it pulled out the tourism to put pressure on Palau to de-recognize Taiwan. Japan was going to step into the breach to build up the lost tourism, which shows how useful Japan can be. And then COVID came. That track stopped. Meanwhile, Palau offered to host new U.S. military facilities in September 2020. U.S. Operation Warp Speed for the vaccines included the freely associated states, and Palau, which mercifully did not suffer any COVID cases, was largely vaccinated very quickly. Palau began its withdrawal from the Pacific Island Forum. It was one of the Micronesian states that withdrew. Palau and Taiwan opened one of the first travel bubbles in Asia. And on that trip, the president of Palau brought along the US ambassador to Palau to Taiwan with him. At the same time, Taiwan and the US signed a Coast Guard agreement, and there's rumors that potentially Palau might be included at some point as well. And Alexander Gray, who's formerly held the National Security Council seat in the US on Oceania, has just published a piece recommending that COFAs be offered to Kiribati, Nauru, and Tuvalu to extend this sort of engagement. So we're in a very dynamic maritime security situation now in the Pacific, where new agreements are being proposed, old agreements may be falling out of efficacy. And in fact, we are very bluntly going back to a situation where in some capitals, they're looking at the World War II map and seeing where those conflicts were along the islands, the small island states. And so the maritime security issues in the Pacific are not just what you would expect in terms of fisheries and transnational crime and human trafficking and all that sort of stuff. We're going back to a hardcore security situation where islands have the potential to become bases where they weren't bases before and become targets where they weren't targets before. So that's it. Thank you very much.
Thank you, Cleo, for that excellent presentation. Very interesting. And look forward to some questions when we're through here. If I could please ask the Secretariat to start streaming Lieutenant Commander Polynesia Doulaire's presentation. Thank you.
Hello, I am Lieutenant Commander Dominique Bourgnon-Delaire. I am the Maritime Law Enforcement Officer of the French Pacific Command, based in French Polynesia in Tahiti. Thank you very much for welcoming me to this conference. I'm going to speak about maritime security issues concerning small island states. I'm going to talk about the place of France in the Pacific, the place of the French territories, New Caledonia and French Polynesia in the Pacific, and how they are existing within the Pacific Island countries ecosystem, and how France sees the Pacific Island countries' maritime security issues from these territories and thanks to this presence in the Pacific. So the Pacific Island countries experience a wide range of maritime security issues. They are facing environmental threats like increased frequency of climate disasters or rising of the sea level, as well as illegal activities threats like illegal fishing, drug trafficking, sea robbery, human trafficking. And all these threats are challenging the sovereignty of these Pacific Island countries. Moreover, these countries, and this is often the reality, are often seen as small and weak islands with limited financial resources and a poor governance, and therefore maritime security issues justify dynamic operations of cooperation with them. One of the biggest challenges in the region is the size of the area. The distances are very big, And just to give you an example, just for French Polynesia, between the North Islands and the South Islands, so the 118 islands of French Polynesia are spread out on an area as big as Europe. And when you're flying from the north to the south, from the Marquise Island in the north to the Gambier Island in the south, you're flying over 4,000 kilometers, which is about the distance between Copenhagen in Denmark to the very south of Italy. And this is only French Polynesia, and so this the size of the area makes the addressing of maritime security issues more complex. So in the region, thanks to its two territories, French Polynesia and New Caledonia, New Caledonia is situated next to Australia and New Zealand, and French Polynesia is really in the middle of the Pacific Ocean. And thanks to these two territories, France is recognized as a vector of political stability, an actor for regional security, and a significant partner for economic development. More generally, I would like to stress that France is concerned by international common safety and security all over the world, but particularly in the Pacific Ocean, where great powers competition is rising up. And as a nuclear power and permanent member of the United Nations Security Council, France has a sharp conscience of its international responsibilities and therefore maintains a core ability to deploy joint forces worldwide and to honor bilateral and multilateral security agreements. Moreover, France is one of the few European states to maintain permanent military assets in the Pacific, which ensures a constant presence on this part of the world. Through regular naval deployments across the South China Sea and the Pacific Ocean, France strongly affirmed the value of the existing international law-based order, and especially for maritime issues, the United Nations Law on the Sea Convention. Law of the Sea Convention. So French armed forces in the Pacific are organized around a regional command in charge of all French operations conducted throughout the Pacific Ocean, based in Papeete in Tahiti, called ALPACI, which is the acronym for the admiral commanding the Pacific region. And this main command is completed by a local command in New Caledonia. Regarding maritime issues, the French Navy has two kind of missions. The military missions, like enforcing international law, enforcing international law of the sea, and Coast Guard missions. France has no Coast Guards like many Anglo-Saxon countries, but still has Coast Guard missions, and these missions are fulfilled by the existing administrations, especially the Navy, which has the biggest means, but also by all the other administrations and agencies. And so the Navy is fulfilling in the Pacific Ocean these military missions and these Coast Guard missions, which are, among others, fighting illegal fishing, protecting the environment and fighting maritime pollutions, fighting drug trafficking, etc. So the French Navy is operating from these territories, French Polynesia and New Caledonia, to address maritime security issues. And this brings me to the question: what is the place of French Polynesia and New Caledonia in France's institution and within the Pacific Island countries' ecosystem? French Polynesia and New Caledonia could be seen as Pacific Island countries, but they are not. French Polynesia and New Caledonia are fully part of France, like any other French overseas territory, such as La Martinique in the Caribbean, or Corsica in the Mediterranean Sea, or La Réunion in the Indian Ocean. But in order to take into account the cultural particularities, the French Constitution, in its paragraph 74, allows Polynesia and New Caledonia to adopt their own laws in large but limited areas, such as environment protection, tax policy, insurance, etc. And for this, they have their own institutions, a territorial assembly, president, ministers, institutions which have been created by what we call the autonomy statutes. The national authorities, so national authorities or central authorities by opposition to local or territorial authorities, the national authorities are represented by a high commissioner, which represents the French government and exercises its powers in the full spectrum of the classical state powers like justice, diplomacy, war, currency. And yes, so so French Polynesia and New Caledonia are very far from each other, but the high commissioners are coordinating their activity, and the territorial authorities are more or less coordinating their activity also. So not in every field of activity, but especially in the field of cooperation with the Pacific Island countries. Just one point interesting to know, the diplomacy is reserved to central authorities, represented by the High Commissioner, and the representation within the international organizations is reserved to the Foreign Office, but so the French Foreign Office, but in the autonomy status, there is a disposition allowing the territories to be represented in some regional organizations, and they must obtain the agreements of the Foreign Office, and it is the case for the Pacific Island Forum and for the fishing the regional fishing organization, the Western Pacific and Central WCP Fishing Commission, FC. Yes. Last point, because of their large autonomy, these territories are out of the European Union sphere of competence. This means, for example, that the fishing regulations are left to the local institutions, while on the continent, fishing issues are totally integrated and led by the European Commission. In other words, member states have no more sovereign powers on the field of maritime issues on the continent. But here, because the territory has a large autonomy, and especially in regulating its fishing resource, and the central authorities are in charge of implementing the local regulation and exercising surveillance and control. They are out of the European Union sphere of competence. So how does the cooperation with the Pacific Island countries work? There are three main topics: assistance to natural disasters, protection of the environment, and fishing issues. These are the three main axes of cooperation, and yes, the three main ways of addressing maritime security issues with our neighbors. For national authorities, the solidarity with the Pacific Island countries for their maritime security relies on a good coordination with our allies through the Pacific Quad and the France agreements, which are the privileged framework for surveillance operations and intervention in case of natural disasters, as it was the case in Vanuatu in 2015 and Fiji in 2016, where help was provided through the France agreements. The France agreement is an operational agreement since 1992, agreement of exchange of information allowing a trilateral coordination of the means of intervention against natural disasters in the region. The Pacific Quad is more focused on fishing surveillance and coordinating surveillance operation between the navies and the coast guards of the region. So, as I said, the territories, New Caledonia and French Polynesia, are represented in the Pacific Island Forum. The national authorities are not represented in the Pacific Island Forum. This forum is less focused on maritime issues, but maritime security issues. But still, it is an important forum, which aims at which acts for the Pacific Island countries' stability and economic development. It is a main intergovernmental organization of political dialogue in Oceania, and despitefully, in February 2021, Palau, followed by the federal state of Micronesia, Marshall Island, Nauru, Kiribati, have left the Pacific Island Forum after some issues regarding the election of the General Secretary. So, concerning the protection of the environment and the fight against maritime pollution, the international framework is relies on two main tools: the SPREP and the PAC plan. The SPREP, Pacific Region Environment Program. It's a program which acts in different fields, so climate change, biodiversity and ecosystem-based control, fight against pollution and environmental surveillance, and governance. And within the SPREP, there is an agreement, the PAC plan, which is a framework for intervention and mutual help in case of major maritime pollution. Beside these tools, France is offering a bilateral cooperation by offering places to Pacific Island countries observers when we are organizing trainings. And also, French Navy ships are offering trainings when they are calling in Pacific Island countries' ports. And it has not been the case recently, but I would like to stress that French Polynesia and New Caledonia, it is France. There is a unity between these two countries and these two territories. And France has put in place a robust response organization able to coordinate the action between the two territories, and modern means able to contribute to fight a major pollution. I mean, these two territories are already large maritime areas to protect themselves, but they are ready to provide assistance and help to our neighbors. And in case of a catastrophe in a Pacific Island country, like for example, we can think to the wreckage of the oil transporter in Mauritius in August 2020, which provoked a big oil spill in Mauritius. And this is a scenario which could happen everywhere in the region. France, in close coordination with its partners, New Zealand, Australia, and the US, due to this position in New Caledonia and French Polynesia, France will be able to provide rapidly means for intervention and a high-level expertise to help the Pacific Island countries. So that was for the environment. Now, I think one of the biggest issues in the region and for the Pacific Island countries is the fishing issue. The Pacific Ocean owns the world's largest fishing resources, but they are clearly threatened by the illegal, unreported, and unregulated fishing, which is a concern for any coastal state intending to defend its economic exclusive zone, but also a global concern to avoid overfishing, which could hamper sustainability. The problem of many Pacific Island countries are, first, their addiction to the fishing licenses selling system, and second, their scarce means of surveillance and control. Concerning the first point, their addiction to the fishing license selling system. I'll give one example. French Polynesian authorities, in close cooperation with Paris, have courageously chosen in 1996 to stop selling licenses to foreign countries. And they decided to build their own industry tool, from naval construction to fish trading export distribution network. This allowed the creation of numerous local employment to reinforce the economic reliance of the territory, because there are not so many resources and the country is living of a lot of tourism. It reduced the dependence to big fishing countries, as well as the fishing pressure on the resource. That was a good choice from our point of view, and that was a decision of the local authorities. And this would be an example to follow for the Pacific Island countries if they can stop this addiction. It would be a good way to find again the way of sovereignty on their resource. Concerning the second point, the rarity of means of surveillance and control. We all know how expensive and complex it is to own boats and train agents. And building an efficient at-sea surveillance and control tool requires from the state heavy efforts and long-term investment policy. And for many Pacific Island countries, this requires support from big nations. Because it requires really a lot of energy to build this tool, able to control, to bring in front of a court the people arrested, It requires many people, good organization, lots of budgetary, lot of budget. So that's a challenge, and lots of these countries are too weak to build these tools, and therefore they need the big nations to help. And therefore, France offers an interesting model for smaller countries of a Coast Guard function, as I said in my introduction. The Navy, the France has no Coast Guards, but we have a Coast Guard function relying on one authority coordinating all agencies and administrations, owning means and exercising powers at sea. Mainly the Navy, but also the customs, police, gendarmerie, maritime affairs, etc. And the advantage of this organization is that it relies on the existing means and do not require to create a new administration. Anyway, for the fishing, there are international organizations. So regional organization, the Fishing Forum Agency, which acts for the reinforcement of the national capacities and regional solidarities for a sustainable fishing activity of tuna in the Pacific. And the WCPFC, Western and Central Pacific Fishing Commission, which ensures the management of sustainable fishery of tuna stocks and migrating fishes in the west and center of the Pacific. The WCPFC regulations are very interesting because they are allowing the boarding of fishing boats in the high seas without prior flag state authorization. In French Polynesia, so around French Polynesia, around the EEZ, France does on average 66 boarding per year, and around 300 interrogations by airplane or navy ships. And from our Maritime Information Fusion Center based in Tahiti, we are monitoring about 1,700 fishing vessels per year through satellite and electronic detection means. We are coordinating with the Maritime Information Fusion Center, recently created in New Caledonia. And we share the same maritime picture, and we share it with our partners of the Pacific Island countries. And we are trying to build up a net in order to reinforce the capacity to control the illegal fishing activity in the region. So within the framework of these two organizations, FFA and WCPFC, we are also conducting a bilateral cooperation with our neighbors. And for example, we are often with their crossing the EEZ of other countries, and when they agree, we are patrolling in their EEZ, and we are reporting the maritime picture we observe in order to allow the coastal state to control if the fishing ships observed in the EEZ are allowed to fish or not, and possibly begin a procedure against these vessels. So France is also, so that was for the fishing. France is also cooperating from these countries to many defense and security forums and exercises with its allies and with its neighbors. So the Admiral Alpassi nurtures relationships with almost the totality of the countries in the region, 10 to 12 countries visited by Alpassi each year, generating over 70 bilateral high-level meetings training, seminars, classes, etc. And France participates to the main exercises like international exercises like RIMPAC, MPAT, UFJ, KR, sorry, and organizes major exercises each year, like Croix du Sud in New Caledonia, or Marara in French Polynesia. Well, as a conclusion, I would say that maritime security issues in the region is, and especially cooperation with Pacific Island countries, is clearly part of the French Indo-Pacific policy. And France will increase its efforts in its efforts in the field of cooperation with Pacific Island countries in the coming years. But we are all hoping of a prompt end of the pandemic, because obviously the COVID-19 has worsened the existing tensions in the region and weakened the relationships built up through the time, and as I said, as we saw in the Pacific Island Forum, the countries who left, it's a sign, a weak sign of the weakening of the human relations between the people in the region, and these difficulties generated by COVID-19 possibly created vulnerabilities in some countries which could be exploited by competitors. And therefore, we shall, maybe more than before, remain vigilant and increase multilateral cooperation in the region. This concludes my presentation. Thank you very much for listening to me, and goodbye.
Okay, thank you. Unfortunately, Dominique will be unable to join us for Q&A, but our next speaker will be Professor Kurosaki.
Am I audible, Pete? Okay. Thank you, Professor Pedrosa, for your kind, generous introduction, and thank you also to the organizers for the invite and having me. So, good day to everyone. I am Masahiro Kurosaki, an associate professor of international law at the National Defense Academy of Japan. And today, I'm going to talk about what is the best option for the coastal states' law enforcement action against foreign state vessels, namely warships and other government ships on non-commercial service, in order to protect its territorial waters as a peaceful maritime engagement without using prohibited armed force. So my presentation does not aim to address the issue on small island states squarely, but I still believe my presentation is also relevant to maritime security issues concerning small island states, and as such fits the theme of this session. So now I'm going to share my screen, hopefully to help you understand my remarks.
That's good. We can see them.
Yep. So coastal states may take all necessary measures in accordance with international law to protect its territorial waters and its peace, good order, or security from the conduct of harmful activities by foreign vessels. Yet the matter becomes more complicated when such activities are carried out by foreign state vessels. Since its law enforcement measures could, depending on circumstances, lead up to the prohibited use of force against the flag state, the coastal state would need to take careful steps to avoid escalating the situation into the use of force under armed conflict, particularly where it forcibly evicts those vessels from its territory. So against this background, this presentation aims to offer the optimal legal framework for de-escalating a coastal state's maritime law enforcement action against foreign flagged state vessels navigating in its territorial sea. So in doing so, I examine three possible options for the legal basis for the coastal state's action, as already shown in my PowerPoint slide. First, the coastal state's right of protection against non-innocent passage under Article 25, Paragraph 1 of UNCLOS, the UN Convention on the Law of the Sea. And second, a general right of self-protection against a forcible threat to a state's legal rights. And third, the right of an injured state to resort to countermeasures under the law of state responsibility. So I think the first option concerning the UNCLOS right of protection is the first and foremost legal basis to be considered and relied upon by the coastal states, because it is provided in Article 25, Paragraph 1 UNCLOS, which is a treaty provision. And as such, some might think that this provides the coastal states with the solid legal basis, and that it's the best option for the protective action against the foreign state vessels. But as you can see, the problem is that it doesn't clarify to what extent and what concrete actions the coastal state is authorized to take by this provision. And actually, Article 25, Paragraph 1 doesn't say anything about the contour of its law enforcement action against the foreign state vessels. So some opine that the coastal state is entitled to do anything to protect its territorial waters against the foreign state vessel, to the extent that it does not amount to the prohibited use of force. And on the flip side, others argue that Article 25 must be read in conjunction with other UNCLOS provisions, limiting the maritime law enforcement action by the coastal states, highlighting Article 30 and Article 32. And as you can see, Article 30 only permits the coastal state to require foreign warships to leave the territorial sea immediately, meaning that the coastal state is not allowed to conduct any compulsory measures against foreign state vessels, because Article 32 does provide nothing in this convention affect the immunities of warships and other government ships operated for non-commercial purposes. But as those diverging views show, the issue remains controversial among international law scholar experts, combined with the scarcity of relevant state practice surrounding Article 25, Paragraph 1 on the coastal state's right of this right of protection. So the first option is beset by the unresolved issue of whether and to what extent the protective action is inhibited by the immunity and inviolability of foreign state vessels under the UNCLOS regime, which would undermine the legality of the action in question, and as such, runs the risk of escalating the situation into the use of force between the coastal states and flag states. And Now turning to the second option, the coastal states may alternatively rely on a general right of self-protection against a forcible threat to a state's legal rights. It must be noted that this is not the inherent right of self-defense against armed attack as enshrined in Article 51 of the UN Charter. This customary right of self-protection, as distinct from the right of self-defense, has rather been invoked to warrant forcible intervention or minor uses of force by states, not amounting to the prohibited use of force in the sense of Article 2.4 of the UN Charter. Indeed, it could be posited that the existence of this right of protection was hinted by the ICJ judgment in the Gulf Channel case. In that case, the United Kingdom sent warships into Albanian territorial waters and carried out minesweeping operations therein. And the courts found that the British violation of Albanian sovereignty. So what needs to be noted here is that the ICJ did not find the British violation of the prohibition on the use of force, but instead found its violations of Albanian sovereignty alone. In the same vein, the UK, for its part, did not justify its action on the basis of the right of the use of force in self-defense, but relied on its right of self-protection against a forcible threat to its right of innocent passage in Albanian territorial waters. So all of these suggest that there is such a customary right of self-protection other than the right of self-defense in international law. And this right has been subsequently advocated predominantly by the British international law scholars like Oxford professors Humphrey Wardock and Ian Brownlee, and the Japanese government as well, in an effort to justify its forcible activities below the threshold of the prohibited use of force carried out outside the sovereign territories of other states. All that said, it would be hard to assert that this general right of protection has attained wide explicit recognition by many states. Besides, there is also the thorny issue of how to reconcile this general right of protection with the Caroline Doctrine, or the Webster formula on the inherent right of self-defense against imminent threats, which is not limited to armed attack in the US position, that the United States has actually long asserted to warrant its use of force. As such, even if the coastal state seeks to justify its law enforcement action against foreign state vessels based on this general right of protection as distinct from the right of self-defense, arguing that it's distinct from that, the prohibited use of force, it's not quite different from that, but the flag states and other states like the United States might still consider it as the prohibited use of force, unless otherwise justified in self-defense or authorized by the UN Security Council. Therefore, allows its counter use of force against that coastal states. So relying on this second option will also likely endanger the situation between those states, even granting that it is minor or moderate use of force against foreign state vessels. In contrast, the third option, which in turn concerns the coastal state's countermeasure against the violation of its territorial waters committed by the flag states, is more tenable and instrumental in averting the interstate use of force and armed conflict compared to other 2 points. The law of countermeasure is not just well-established rule of international law on the circumstances precluding wrongfulness, which could justify the coastal states' possible infringement of the immunity and inviolability of foreign state vessels. But it also comprehends its own institutional mechanism for the escalation that is composed of dynamic safeguard procedures to ensure the peaceful settlement of international disputes. That is already provided in Articles 49 to 53 of the ILC Articles on State Responsibility. Most notably, the notification and negotiation requirements play a crucial role and functional role as well in helping reduce the likelihood of escalating the encounter between the coastal states and flag states, and therefore should be leveraged in combination with the strengthening and update of the existing maritime confidence building measures, such as the Code for Unplanned Encounters at Sea among the Pacific nations, established in an effort to facilitate communication when naval ships or naval aircraft encounter each other in an unplanned manner. And as provided in ILC Articles on State Responsibility, the countermeasures taken by the coastal state as an injured state shall not involve the use of force in the sense of Article 2.4 of the UN Charter, but at the moment, views are split on the threshold of the use of force under armed conflict as well. In fact, some argue that a hostile intent of the state in question is the crucial element for the qualification, and others contend that the intensity is everything in the end. But whichever of these positions is adopted, de-escalating the situation between the coastal state and the flag state would, by definition, reduce the hostile intent and the amount of force employed in the situation. So lawful countermeasures, namely proportional and temporary or reversible countermeasures aimed at inducing the responsible state to cease the wrongful conduct and resuming the performance of the obligation breached, would highly likely contribute to the peaceful settlement of the situation between the coastal state and the flag state without the resort to the prohibited use of force. And as such, the option of countermeasures most fits the purpose of peaceful maritime engagements. So, for the reasons above, I conclude that, the optimal legal framework for the coastal states, the protective action against the foreign state vessels, is its right to take countermeasures. It does provide the solid legal foundation for the enforcement measures and is the most conducive to the peaceful settlement of disputes between the coastal states and the flag state as compared to other two options. And that concludes my presentation. Thank you very much.
Thank you very much, Masahiro, for that very interesting presentation. We have time for some questions now. Let's see, a few have come in the chat. First, for Professor Kurosaki, what is your view regarding the China Coast Guard law that will possibly be applied around the Senkaku Islands?
May I?
Please.
Okay. Well, so as for the question raised, if you ask me, everything comes down to the problem of the territorial title to the Senkaku Islands. And because my argument that the optimal legal framework for maritime law enforcement by the coastal state against the foreign state vessel is the right to countermeasures. This argument was also similarly applicable to the Chinese side when they want to exercise or conduct some maritime law enforcement measures against Japanese state vessels. So I'm not sure to what extent the Chinese government adopts the position on the precise legal basis for their maritime law enforcement action, particularly in relation to the foreign state vessels, including warships and other government ships operated for non-commercial purposes. But given that the China is a contracting party to the UNCLOS, they are of course entitled to invoke to Article 51, Paragraph 1 of UNCLOS as the legal basis for their enforcement action against the Japanese foreign vessels, and also in fact the recently enacted Chinese Coast Guard law clearly authorizes the Chinese Coast Guard vessels to do such enforcement action against their foreign state vessels, despite the provisions of the immunity of foreign ships and other government ships on non-commercial service. So I suppose that they also have the same three options for invoking and justifying their maritime enforcement actions against the Japanese vessels and other foreign states vessels everywhere, as long as within its territorial waters. But it belongs. So that's why I thought that everything comes down to this issue, the territorial title to the Senkaku Islands. So which countries has the legal title to that island? So that's my tentative answer to the first question. I'm not sure to what extent if I could answer to that question. But again, so the territorial title matters very much in that case. Thank you.
I guess just a follow-up from me, how would you view a use of force by a China Coast Guard vessel against a Japanese Coast Guard vessel in the territorial sea of the Senkakus, where a Japanese Coast Guard vessel may be coming to the assistance of a Japanese fishing vessel? And Cleo, you can weigh in on that as well if you like.
Is this also to my question, right? Yes, also because there is two types of vessels involved in that case: fishing vessels, merchant vessels, and the government ships, which is as distinct from warships, because the Japanese Coast Guard is not characterized and not qualified as warships in the sense of the UNCLOS provision. So, but they surely enjoy the right of immunity and inviolability under UNCLOS. So even if the Japanese Coast Guard is coming to aid and assist of the Japanese fishing vessels in the same within the Japanese territorial waters, or they also have the right to claim that the right of immunity and inviolability encountering the Chinese Coast Guard vessels. And even if they claim various rights and for their legal basis, in my opinion, the Japanese government should stick to their peacetime rights of immunity and inviolability authorized by the UNCLOS on about the state vessels, even if the purpose of sending the Japanese vessels by state vessels by the government is to protect and come to aid of the Japanese fishing vessels. But it's a very practically this question would be very hard to understand to answer. But theoretically, the fishing vessels are of course are not immune from that enforcement action by the Chinese Coast Guard. So using armed force or firearms as well.
Thank you. Cleo, let me ask you a question. Did the Chinese indicate what provisions of UNCLOS they they view as no longer being relevant in 2024? Was it the entire convention, or was it just certain provisions of the convention? What was their problems with the convention?
So we didn't drill down into specifics. It was more to get a sense. The question was more indicative to get a sense of how seriously they take international agreements generally in the context of the lawfare component of the three warfares. And I was quite surprised. I mean, you have to always question the information you get out of China. I mean, why are they telling you whatever they're telling you? But it was consistent with actions we've seen on the ground, and so we have a real problem, because if Beijing is using this lawfare approach to international engagement, do you try to adjust the laws? The question that was just asked about what do you do when something's a fishing vessel and not a warship and all that sort of stuff? Well, we know that's the gray zone that China loves to wander around in. So do you try to, as law-abiding nations who see the value in international agreements, do we try to adapt our laws to that kind of attack, lawfare attack? Or do we say, no, this is what the laws are, and we're going to enforce them as they are now, and not try to figure out how to incorporate when what's a dual-use vessel is masquerading as a fishing boat, but actually has quite a lot of PLA soldiers on it, PLA soldiers on it. So this is this kind of core question that we're all facing at the moment. And I don't know if I'm allowed to ask the moderator a question, but that would be my question to you: is what are we supposed to do about this?
Okay, I'll save time for other questions rather than have me answer. But we'll talk offline on that. I have my views on what to do with gray zone operations, which to me plays into the hand of the Chinese lawfare argument when they say something's in the gray zone and everybody buys into it. I think that's a mistake, and we shouldn't be doing it.
Thank you for saying that. Yeah.
Excuse me, Peter. Yeah, let me add one point to the question raised by Claire Pascal, because my presentation is, I think, partially respond to your question raised by asking if to what extent the UNCLOS has legitimacy in the current situations surrounding maritime security, so if I'm correct. So my argument is that, as I said earlier, the relevant provision of UNCLOS do not provide explicit and standalone basis for maritime law enforcement by the coastal state against foreign state vessels. So it needs to be highlighted that in that sense, as this shows, UNCLOS does not offer workable and a practical legal framework of maritime security, including the use of force and armed conflict issues. So having said that, answering to the Pete's questions, Japan should stick to the UNCLOS regime. But having said that, that's one of the reasons why I thought I should depart from the UNCLOS regime to seek for the optimal legal framework of maritime law enforcement by the coastal state against the foreign flag vessels, because the UNCLOS regime does not. It's not simply useful when it comes to the use of force and armed conflict issues. As a matter of fact, it doesn't say anything about it. So in that sense, I have no choice but to looking on other legal regimes, even if it's customary one, because for the Japanese side, the treaty provision is everything, because it is ratified by the parliament's Japanese Diet's legislature. So in terms of democracy, it's very important, at least at the domestic level, because on the international law plane, there is no requirement of the approval of the legislature within the country. But when it comes to the legitimacy again, so also the approval of the diet is very important. So that's one of the reasons why the Japanese government is attaches high value to the UNCLOS treaty regimes. But when it comes to, again, given the current tense situations around Japanese and Japan and other countries in the Indo-Pacific, the situation is quite different from the time the UNCLOS adopted. But so that's one reason why. So I just want to it's the one point just I wanted to highlight. So to what extent the UNCLOS regime is workable and practical and meaningful to the issue of the maritime security, particularly in the context of the maritime law enforcement by the coastal state against the foreign state vessels in the name of the protection of the coastal states' peace, good order, and security. So I'm not sure if I could answer to respond to your question, but I thought this is very important and relevant to the overall theme of the topic. So that's all.
Thank you. Masahiro, a question from a good friend, Peter Bowers. He would like to know whether you construe the reliance on the lesser use of force as distinct from unit self-defense, or is it akin to that right?
If I'm correct, despite knowing that there exists some written manual on the use of force mentioning the existence of the unit self-defense, my sense is that that right is only unique to the U.S. Armed Forces as a matter of positive international law, and also the reason why I think so is primarily because I'm not an expert of the U.S. perspective on international law, so maybe Pete can respond to more correctly. But the unit self-defense is the commander's obligation, right? Not merely a right. So in that point is a crucial difference from the right of self-defense in the sense of our current understanding of the right as at the level of international law. So that's why I generally, my understanding, and I believe that the Japanese government share the same opinion towards the legal character and legal nature of the rights of the unit self-defense. It's not merely a right, it's also the obligation for the commander. So what do you think, Pete? Am I right?
As you know, the U.S. position is we view any use of force as rising to the level of giving us the right of self-defense. Mm-hmm. We don't buy into the gap theory that there has to be a certain degree of force before you can use self-defense. So any use of force against a U.S. warship or a U.S. Coast Guard vessel would be viewed as an unlawful use of force that would give rise to the right of self-defense under Article 51 of the Charter for the U.S. So
is that the military commanders is entitled to judge the existence of the illegal use of force, triggering the right of the U.S. national self-defense, right? So, it's the government that have the legal rights to determine the existence of the illegal use of force. I think it can be judged in line with the hostile intent or the demonstrated intent. I don't remember correctly, but maybe the judgment requirements or elements would be the hostile act or the demonstration of hostile intent. But it is to be judged by either by the government or the commanders on the spot, which would be the who would be entitled.
The commander on the spot has the obligation to use self-defense in response to a hostile act or hostile intent.
Exercising his duty to unit self-defense.
Unit self-defense, yes.
Okay, so that's also distinct from my understanding. It's only the government in Japan. It's a cabinet is only entitled to make a decision of the existence of such a situation triggering the right of self-defense.
Okay. Cleo, a question for you. You spoke about the possibly expanding the concept of the COFA, the Compact of Free Association, to other nations Could you expand a little bit on that? And also, the compact is not just about security guarantees and things of that nature, but it also has a money string to it. So it's not just we're providing security guarantees, but there's also some financial assistance that goes along with that. And under the Pacific Pledge last year, you saw quite a bit of new money being infused into the region for the small Pacific Island countries. And Senator, or I should say Representative Case, has just reintroduced his Blue Pacific Act that will pump another $1 billion into the region. So could you perhaps expand a little bit on that?
Sure. So obviously, this would have to be led by the countries themselves. And there's some indication that at least one of the three that I mentioned does have some interest. But there's a lot of maneuvering to happen on both sides. This is a relatively new idea to come out into the public discussion. Not only is there a money component, there's the ability to come and work in the U.S. There are a lot of members of COFA countries currently serve in the U.S. military, a higher proportion than almost any other state in the U.S. So it's a real interlinking of social services, people, but a component of it is the U.S. essentially takes over a large component of the hard defense of the country. So it's a very, very big decision to make. Of the three countries that were mentioned, Tuvalu, Kiribati, and Nauru, two of them recognize Taiwan. Nauru is one of the Micronesian countries and Kiribati that just pulled out of the Pacific Island Forum. It was very interesting to hear the presentation from our French colleague, because France through New Caledonia and French Polynesia has votes in the Pacific Island Forum. New Caledonia didn't vote. French Polynesia did and voted with Australia and New Zealand to essentially fracture the Pacific Island Forum. So we don't really know what's going on with that French element. But because of that division, there may be more appetite among Micronesian countries now to take a look at a closer relationship with the U.S. The other two countries that may also want to look at this sort of a closer relationship are Japan, not replicating the U.S. COFA, but similar in some respects. Some of these countries, and potentially even Taiwan. So there's an opening now for new sorts of engagements for some of the reasons that our French colleague mentioned. These are countries that are very difficult to protect. They're very large areas. They have limited naval capacity. They do seem to need help in some of those sectors. But I'm very cautious about creating a situation where dependency is the norm, because then that might lead to a Chinese COFA sort of situation being offered. So it needs to really suit both players in a way that strengthens actually their independence as opposed to making them more dependent.
Thank you. I think we have time for one more question, and Masahiro, it's directed to you. Japan is trying to organize the Japan-Pacific Islands Defense Dialogue. Do you think it is possible to invite Taiwan to the dialogue, even only as an observer? And do you think it's possible to put the Taiwan issue on the agenda?
Thank you. I think it's not a legal issue, it's a political one or a matter of policy, but I'm not an expert on that field. But hopefully, we should put Taiwan in that dialogue as an observer in a strict legal sense. In my understanding, and I'm sure that Japan does not recognize Taiwan as a sovereign state. It's based upon the joint communique between People's Republic of China and Japan, and the Japanese government recognizes the Beijing and Peking as the sole government of China, and we don't touch upon. May I? we don't touch upon the issue, the who is belong to Taiwan. So it's a clearly that's the basic line of the Japanese government, if I understand it. So we don't touch upon that. The legal status of Taiwan. It's simply respect the Chinese government's position. So we don't say anything about the legal status, meaning, though it does not mean that the Japanese government recognizes the legal status of Taiwan at all. So that's why, so factually speaking, the best way is to invite Taiwan as an observer. But it's not about a game, it's a legal matter. It's not about a legal matter. Thank you.
Okay, thank you. All right,
If I could just jump in just super quick.
Sure.
If that happened, which of course would be lovely, I suspect some of the Pacific Island countries like Fiji wouldn't attend. So you have to kind of understand the operational realities of some of the countries that are further down that support to dependency trajectory.
Okay, well, let me thank our panelists for their excellent presentations and for taking time out of your busy schedule to join us today. Thank you to the audience for listening to us. We couldn't do much of a conference without the support from the audience, so thank you very much for joining us. And I will turn it back over to the Secretariat, and thank you and good evening.